Hi, this is Stuart Talley. I'm the partner here at Kershaw, Cutter and Ratnoff, responsible for the Stryker Rejuvenate litigation at the firm. And I'm providing an update today on the status of the litigation. Today we had a status conference before Judge Donovan Frank. He is the judge in federal district court who's responsible for handling and managing the numerous Stryker Rejuvenate cases that are pending around the country. He's based in Minneapolis, Minnesota, and he has status conferences about once a month to go over the status of the case and to ensure that the litigation is progressing forward in a timely and efficient manner. A couple of issues were addressed today. The first was um, Judge Frank indicated that he had been reaching out to judges in other courts, uh, specifically state courts, where some of the Stryker Rejuvenate cases are pending. There are some cases pending in New Jersey, some in Florida, some in Oregon in state court. And so Judge Frank reached out to judges in those courts to make sure that there's coordination between all of these courts. What Judge Frank does not want is different courts making different rulings, managing the case in their own way, which can lead to chaos and inefficiencies at the end of the day. So that was the first thing that Judge Frank talked about. Next, he talked about what's commonly known as a plaintiff fact sheet. In large cases like this, where you have thousands of lawsuits all involving the same product or device, it's very inefficient to allow what we call full-blown discovery in the case. And so to expedite things, what happens is the court will issue an order indicating that anyone who has a case has to fill out what's called a plaintiff fact sheet. A plaintiff fact sheet is essentially a large questionnaire that each plaintiff has to fill out. It asks for information such as your treating doctors, when your hip was put in, when it was taken out, if it was taken out, and asks for basic information about your medical history and whether you have lost learning, things like that. So he entered an order that requires a plaintiff fact sheet to be filled out. It's a fact sheet that was negotiated between the plaintiffs and the defendants. And within 60 days, most people who have cases on file will have to submit plaintiff fact sheets to the defendant. The other issue that was discussed is the judge looked at and will be entering, it appears, a protective order. There's some issues with that protective order that may need to be addressed later on, but basically it is a order that protects the documents that Stryker produces in discovery. In these cases, millions of pages of documents are typically produced. Emails, blueprints for the hip, design documents, scientific documents showing how the hip was tested. And so a lot of these things contain highly proprietary or confidential information that Stryker would not want their competitors to see. So the protective order is typically put in place to protect those documents so that the lawyers or anyone who comes into possession of these documents doesn't reveal them to the public. Now, the big dispute at issue is there's a clause in the protective order that Stryker wants that would prevent the plaintiffs from essentially showing protected documents to experts who might work for a competitor. Unfortunately, in these cases, most of the experts are competitors of Stryker or any other hip manufacturer. So that is a big problem for the plaintiffs, and that's an issue that is going to be briefed and decided by Judge Frank at the next status conference, which is next month. The other thing that was discussed, that was teed up, is the issue of what we call electronic discovery. In cases like this, a large amount of resources are dedicated to obtaining documents from the defendants. Usually this involves millions of pages of documents, most of which are maintained on computers. So what happens is there is a protocol that the parties need to agree on how those documents are going to be extracted from the computers, how the defendants are going to determine which documents are relevant and responsive to document requests that the plaintiffs have served, and then what format those documents are going to be produced. Recently, there has been a lot of discussion about how the documents are searched, essentially how the computer systems are searched. In the past, what typically happened was plaintiffs and defendants would agree on what we call search terms. So we may agree on basically a situation where Stryker would search their computer systems for any document with the word rejuvenate in it, and would produce documents that have that search term in it. And there may be a list of search terms that the parties come up with. What's happened, though, is that there's been a lot of science that have looked at this process of producing documents, and what it's revealed is that search terms alone many times do not produce all of the relevant documents, and in fact they miss a large percentage of them when you're searching millions of documents. So what's been developed by several different companies is something called predictive coding. And the best way to think of it is it's a lot like Pandora, which is an online radio station. Pandora, the way Pandora operates is they play music, and you as the subscriber to Pandora can decide what songs you like and what songs you don't like. And what Pandora does is it has an algorithm that can predict what kinds of songs you will like based on which songs you indicate you like and don't like, and can create playlists based on your preferences. The same concept applies to documents. So what would happen in a case like this is there may be a sampling where you take 1,000 documents off a computer. You go through those documents. You'd have someone from the plaintiff side, someone from the defendant side. Both sides would go through the documents, and if a document appeared to be relevant, it would get a thumbs up. If a document was not relevant, it would get a thumbs down. Well, what these companies have developed is software that will look at which documents are getting thumbs up and thumbs down, and with a very sophisticated algorithm will predict which documents are relevant amongst the millions of documents that were never looked at. All of the evidence has shown, and there's a lot of science on this, that reveals or results in a much better search for documents. A much higher percentage of the relevant documents will end up being produced if you use predictive coding. Stryker doesn't like predictive coding, doesn't like the process, and most likely will resist having this process imposed on them. The issue of predictive coding and the process of getting documents from the defendants is something that's going to be briefed and teed up for a decision or a hearing at the next status conference next month. So that's basically what was discussed today at the status conference. There were some other things discussed, but those are the highlights. Stay tuned to this website, and we intend to provide video updates after each status conference to keep everyone up to date on what's going on with the litigation. If you have any questions, you can always reach us at the phone number on the screen, or you can visit us at the website listed on the screen here.